Hello everyone, myself Dr. Rajashree Jawale, Assistant Professor, DG College of Commerce, Satara. Today we are going to discuss about special contracts. Dear students, in last lecture we were discussing about general contracts. In that we have discussed many aspects. And finally we have discussed about breach of contract and remedies on breach of contract. So in that way we have completed our first topic, and now we are going to start our next topic, and that is special contracts. So in this particular topic we will be discussing about contract of indemnity, contract of guarantee, then contract of bailment and pledge, then contract of agency. So all these are rated as a special contract. So here I would like to tell you that whatever we have discussed and we have understood in earlier lecture with regards to general contract is also applicable over here in case of special contract. That means essential ingredient of a contract: offer, acceptance, valid consent, then free consent, consideration, legal object, and etc. All these elements will be applicable in these special contracts also. So in special contracts, indemnity and guarantee, section 124, then bailment and pledge, section 148, and in case of agency, section 182. These are very important sections. If we discuss about general contract and special contracts are contained in section 124 to 238 of the Indian Contract Act 1872. So in today's lecture we are going to discuss about contract of indemnity and contract of guarantee. So these are the special types of contract which helps from protection against loss in the form of a promise to pay for loss of money or goods. So section 124 to 147 of the Indian Contract Act 1872 discuss about contract of indemnity and guarantee. So here if we talk about principle of indemnity and guarantee, or the contract of indemnity and the guarantee, contract of indemnity and contract of guarantee, these are the specific types of contract. The general principle of contract are fully applicable to such contracts. So in this particular unit we will learn the meaning of contract of indemnity, right of indemnity holder, then indemnifier's liability, etc. You will also study the meaning of contract of guarantee, the difference between contract of indemnity and guarantee, types of guarantee, then rights of surety and discharge of surety from liability. So in exam you may have question like this: define guarantee or define indemnity and explain its essential element. Then distinction between contract of indemnity and contract of guarantee. So what is this contract of indemnity? So under section 124 of the Indian Contract Act, it defines contract of indemnity as a contract by which one party promises to save the other from loss caused to him by the conduct of the promiser himself or by conduct of any other person. So here if we see the meaning, the contract of indemnity is the compensation of security against loss of money or goods. The principle of general law of contract are applicable over here also. So here who are the parties? So there are indemnifier and indemnity holder. So under contract of indemnity, the person who indemnifies or pays the loss is known as indemnifier, and in whose favor such promise is made to pay the loss is known as indemnified or indemnity holder. So it is valid when there is a promise, and this promise is with regard to save another person from loss or make good the loss which may be caused by the conduct of the promiser himself or by the conduct of any other person. Then the promiser undertakes to make good the loss. So it covers indemnity for loss caused by human only. Now we'll see one example. P contracts to indemnify a sum of rupees 5,000 to Q for the loss which may be caused or any proceedings which may be carried on by R against Q. This is a contract of indemnity. So what will include in contract of indemnity? So only express promise to indemnify will include, but not will include implied promise. Only express promise will include and not implied promise. Then in cases where loss is caused by the conduct of the promisor himself or by the conduct of any other person, but will not include what the loss is caused by accident and event not depending on the conduct of the promisor or any other person. So now we'll see about rights of the indemnity holder. So when indemnity holder can sue. So all these things are very essential in case of this indemnity holder. Now we'll see about various rights. Rights are very important. So indemnity holder is entitled some rights when there are loss or any injury. So indemnity holder is entitled to recover all damages which he may be compelled to pay in any case. If case is filed or a suit which should be in respect of a matter covered by the contract only. The indemnity holder is entitled to recover all cost incidental to the suit. That means whatever will be there with respect to suit or filing a case. So if he is filing a case, at that time there may be any expenses which may arise. So even he is entitled to get that money. But he should act as a reasonable prudent man in defending the suit. He should be honest in that. Next is what? The indemnity holder is entitled to recover all sums paid under any compromise of any such suit. But such compromise should not be contrary to the directions of the indemnifier. Next is what? The indemnity holder must have acted prudently in making such a promise. He should not incur unreasonable cost. And fifth one is what? In addition to all these rights, the indemnity holder can file a case for specific performance of the contract of indemnity. So he is having that right to go to the court of law and ask for the remedy of a specific performance. So here these are the rights which are available to the indemnity holder. So indemnity holder is entitled to recover all sums paid under any compromise of any such suit. Now we'll see about very important aspect. So here if we are talking about parties to contract of guarantee, so we'll understand the contract of guarantee is a contract to perform the promise or discharge the liability of a third person in case of his default. So now we'll see this example. In case of contract of guarantee, there are three parties: principal debtor, surety and creditor. So in this example, suppose A is there, principal debtor. A is principal debtor, B is surety, and this dealer is like C. So he is a creditor. So now B is saying on behalf of A to dealer that give a car to my friend A. If A does not pay money, then B will pay money on behalf of A. So here in this case, surety is giving assurance or sure to creditor on behalf of principal debtor, that is B. And here it becomes a contract of guarantee. So here surety, the person who gives the guarantee, is called the surety. Then principal debtor, the person in respect of whose default the guarantee is given, is called the principal debtor. and third one creditor. The person to whom the guarantee is given is called creditor. So these are the parties, and there may be an obligation. So now we'll see about the object of a contract of guarantee. So here the object is to provide additional security by the surety to the creditor in the form of promise to fulfill certain obligations if the principal debtor unable to perform it. So here we'll see again one example. Suppose P promised to pay Q rupees 2000 on behalf of R. If R make default in returning rupees 2000 to Q, here P will pay. Here Q is creditor, R is principal debtor, and P is surety. Now we'll see the features. There are important features of contract of guarantee. So in this case, we have to see that a contract of guarantee may be either oral or in a written form. Then the parties to the contract. So the parties should be competent. The creditor and the surety must be competent to contract. The principal debtor may be incapable of contracting. In that case, surety will be treated as the principal debtor. Then conditional liability. What is this? The liability of the surety is conditional. It only arises if the principal debtor makes a default. And primary liability. There must be a primary liability in some persons other than the surety. So what is this concurrence? A contract of guarantee requires the concurrence of all the three parties. It means all the three parties, that is principal debtor, creditor and surety, should act together at the same time. So these are the features of a contract of guarantee. Now we'll see difference between or distinction between contract of indemnity and contract of guarantee. So now we'll see a contract of indemnity is defined as a contract by which one party promises to save the other person from loss caused to him by the conduct of the promiser himself or by conduct of any other person. And in case of contract of guarantee, this is a contract to perform the promise or discharge the liability of a third person in case of his default. The next is, in case of contract of indemnity, there are two parties, one indemnifier and second is indemnity holder. But in case of contract of guarantee, there are three parties, one creditor, second is principal debtor and third is surety. Next is, in case of contract of indemnity, it protects the promisee from the loss. But in case of the contract of guarantee, it is for the surety of the creditor. Next is what? In contract of indemnity, the primary liability is of the promisor. But in case of contract of guarantee, the primary liability is of principal debtor. In contract of indemnity, there is only one agreement, that is the agreement between indemnifier and indemnity holder. But in case of contract of guarantee, there are three agreements, that is agreement between one, the creditor and the principal debtor, second, agreement between creditor and surety, and third, agreement between principal debtor and surety. Then in case of contract of indemnity, indemnifier cannot sue or file a case against a third party for the loss suffered. But in case of contract of guarantee, surety can sue or file a case against the principal debtor. So these are the distinction points of contract of indemnity and contract of guarantee. Now we'll see the rights of surety. So here, if we talk about contract of indemnity and contract of guarantee, so there are some similar points and there are some points of difference between them also. Now we'll see rights of surety. The rights of surety may be classified under three heads. First, rights against principal debtor. So surety is having right against principal debtor. When the principal debtor makes default and surety pays the debt, the surety stands in the shoes of the creditor. The surety gets all the rights which the creditor has against the debtor. This is called right to subrogation. The surety has right to claim indemnity. So there is an implied promise by the principal debtor to indemnify the surety for rightful payments. Then second, right against the creditor. In this case, a surety is entitled to the benefit of every security which the creditor has against the debtor. He can claim such security from creditor even though he is not aware of its existence. However, the surety cannot claim the benefit only on the payment of the part of the debt. And finally, right against the co-sureties. When two or more persons stands as sureties for the same debt or obligation, they are called co-sureties. All co-sureties are liable to contribute equally or in agreed proportion. Now we'll see this right against the principal debtor. So we have seen that when the surety gets all the rights which the creditor has against the debtor, this is called the right to subrogation. Then right to indemnify, then there may be a right to indemnify the principal debtor. Next, right against the creditor. So right to claim security, then right of set off, right to share reduction. So here reduction will be there in share. Right to ask the creditor to terminate the debtor's services. So all these are the rights against the creditor. So surety is right against the creditor. Now right against the co-sureties. So they have right to contribution. There is bond in different sums. Then right to share benefits of security. These are the rights available against the co-sureties. Now we'll see discharge of surety from liability. So here, how the surety will be discharged from his liability. So when revocation by the surety, when surety itself revoke, then in that case he may be free from the liability. If the surety die, then in that case there may be discharge of surety's liability. Then by variance in the terms of contract, first at the time of entering into a contract the terms were different, and later on terms changes. At that time also surety may be free from liability. He may deny to perform his part. Discharge of principal debtor. So here, if principal debtor discharge his liability, then automatically surety will not be liable for the liability. And then when creditor compounds with, gives time to, or agrees not to sue the principal debtor. So if the creditor is flexible and he is ready and willing to compromise, in that case also surety will not be liable to perform his part. And finally, by loss of the securities by the creditor. So here, when the creditor loses or parts away with any security given to him, at the time of contract, the surety will be discharged from his liability. So these are the important point where surety will be free from his liability. So these are my references. I have used very important book, Dr. J.S. Chowdhury's book on business regulatory framework, Indian contract law by Avtar Singh, then E. Gyanukosh on contract law, and Baer Act on Indian Contract Act 1872. Thank you.